Good morning. I am Dr. Harpreet Kaur, Professor of Law at National Law University, Delhi. Today I will be dealing with Module 8 of the course on corporate law. This module is about listing and delisting of securities and the implications of listing and delisting. So first of all, we need to understand what is meant by listing of securities and then what is delisting. So in this module, the objectives of the modules will be to make you understand the need for mandatory listing of the securities and how it will protect investors' interest, what is a listing agreement, what are the important clauses of listing agreement, and how the securities are delisted and what is the procedure of the delisting and how many types of delistings are there, and how ultimately both these listing and delisting of securities will be beneficial for the investors' interest. So first of all, I will explain to you what is meant by listing and what is listing agreement. So any company which is a public company which wants to go for a public issue of securities has to list its securities on any of the recognized stock exchanges. Now by listing we mean that it has to enter into an agreement to provide a trading facility to its securities on the recognized stock exchange where the listing is done. So this is what is known as listing agreement, and there are number of terms and conditions of this agreement which are in the form of clauses which this public company or the person has to follow. In a short while we will look into different clauses of the listing agreement, where you will be able to realize that how much important this listing agreement is and how it will work for the protection of investors. So over here please understand this, that listing and delisting is dealt by three laws. It is by Companies Act of 2013, Securities Contracts Regulations Act of 1956, and also SEBI Act, which has a number of regulations for the delisting of securities. So all these three will be applicable when we are talking about listing and delisting of securities. So first of all, let us look at how the company goes for allotment of securities. So allotment of securities by any company is done under the provisions of the Companies Act, and the Companies Act under section 40 says that any company which wants to come up with public issue of securities has to make an application to one or more recognized stock exchanges for providing a facility of trading or dealing on the stock exchanges. So the stock exchange where this application has been made has to approve the dealing of securities there. Only then the public issue comes to a success, and only then the company can go ahead with allotment of securities. Now over here, when the company is making application to the stock exchanges, if it is making to more than one stock exchange, all the stock exchanges they have to approve, otherwise company cannot go ahead with the allotment of the securities. Now when this money is received by the company, once the approval is given and the money is received by the company, then this money has to be kept by the company in a separate account, and it should not be utilized for any other purposes for the company, except for the two purposes, that when the shares are allotted or the securities are allotted, the amount will be adjusted against the allotment of the securities, and secondly, in case there has been any reason for which the company has to refund its securities, this amount will be used for the refund of the securities. Now over here it has to be understood that there may be number of reasons for which a public issue may not be successful. For example, minimum subscription. If 90% of the minimum subscription is not received, then the company will have to refund its securities back to the refund the amount back for the securities for which the application for allotment was made by the prospective investor. So once the approval has been given by the stock exchange for listing of securities, the company can go ahead with allotment of securities, and the amount which is collected by the company has to be kept in a separate account. This amount can be utilized only for the two purposes which are prescribed, and it cannot be used by the company for any other purpose. First purpose is that where there has been allotment of securities, this amount will be adjusted for allotment of securities. If there has been any refund, if any refund has to be made on any ground that for any reason the issue has been unsuccessful, then the refund has to be made, then this refund can also come from this separate account. So this is what the refund can be on many number of grounds. For example, for minimum subscription, if the company has not been able to get 90% of minimum subscription for its public issue, then the issue gets failed. So in that case the company has to refund the money which it has collected for allotment of securities. So let us now understand the purpose of Securities Contracts Regulation Act of 1956. So the act was brought into force to meet a specific evil of undesirable transactions like speculations of securities. So section 21 of SCRA 1956 provides for the conditions of listing of securities, and it says that that any person who is applying to the recognized stock exchange for listing of its securities has to comply with the listing agreement. So this is what is the mandatory requirement imposed on the public companies for listing of securities by SCRA 1956. Let us now have a look at and a discussion on the important clauses of the listing agreement, and it is a heavy agreement, contains number of clauses. So I will be focusing only on few important clauses of the listing agreements to make you understand the purpose of the listing agreement for the protection of the investors' interest. So clause 16 talks about closure of transfer books, and it says that 7 days notice has to be given before a company declares its dividend or bonus, comes up with bonus issue or rights issue, or issues shares on the conversion of earlier issued securities. So 7 days notice of closure of transfer book has to be given to the stock exchanges, and similarly if derivatives on the stock are also available, then also 7 days notice is required to be given. Clause 19 is about the board meeting. It says that 2 days before the board meeting, when the decision about buyback of securities or a rights issue or dividend or conversion of securities into different types of securities is to take place or has to be discussed in the meeting, then 2 days notice should be given to the stock exchange. Clause 21 is about interest on debentures and redemption of securities. Over here at least 21 days notice has to be given to the stock exchange when the company is giving interest on the debentures or on any sort of bonds, or it is redeeming its debentures or any securities or shares of the company. So 21 days notice has to be given to the stock exchange. Under clause 24, in principle approval has to be taken from the stock exchange. So if a company is going for further issue of capital, it has to inform to the stock exchange, and it should give total fair, true and adequate disclosures in the prospectus document, and this information should be given to the stock exchange also. And also if the company is going for any reduction or arrangement, merger, amalgamation or any sort of compromise where a scheme has to be sent to the court or the National Company Law Tribunal, then the copy of this scheme or the arrangement has also to be sent to the stock exchanges at least a month before such kind of a transaction takes place. Under clause 28, if there is any change in the form or nature of or the character of the business of the company, then 21 days notice should be given to the stock exchange. Clause 29 says that a prompt notice has to be given to the stock exchange if there has been any change in the nature of the business, and if there is any change in the nature of the securities under section under clause 28, then also 21 days notice has to be given. Clause 30 is about changes in the directorate, etc. So if there is any change in the directorship of the company or the change of the managing director or company secretary or auditors of the company, then prompt notice has to be given to the stock exchanges. Clause 31 is a procedural type of clause, and it says that without application made by the stock exchanges, 6 copies of the statutory and directors annual reports, periodicals, special reports, notices, resolutions, circulars relating to new issue of capital, everything has to be given to the stock exchange, and 3 copies of all notices, call letters or circulars which are sent to the shareholders or to the creditors or to the debenture holders in connection with the scheme of the arrangement or reconstruction, merger, amalgamation, etc. has to be sent to the stock exchange. Clause 32 is about statement of salient features. Now it says that the important portion or provisions of the balance sheet, profit and loss account, auditor's report, it has to be given to the stock exchanges, and if there is any new line of business which the company is undertaking, then the company will have to continuously disclose its turnover and income from such new activity in the annual returns separately for a period of 3 years from the date of this change. So, this is a continual disclosure requirement where the company is taking up any new line of activity or the business, and then company also has to disclose that whatever disclosures are made over here, they are as per the accounting standards which are maintained, which have to be maintained by the company. And similarly, related party transactions, loans, advances which are made by the company, or if the company is making any investments, all this information has to be sent under clause 32 of the listing agreement. Now, clause 35 is about filing of information, where the company has to file an information with the stock exchange showing the shareholding pattern, the details of logged in shares, depository receipts, patterns of the shareholding. This has to be informed. Then clause 35B was added in order to take care of e-voting facility for the shareholders, and because e-voting facility has been given mandated by the Companies Act 2013. So, along with the postal ballots, e-voting facility has also to be provided to the shareholders of the companies. Clause 36 is about information for material events which happen in the company's operations, like there may be strikes or lockouts, or there may be closure on account of power cuts. So, any type of such closure, if there is if it occurs, then the company has to inform the stock exchange both at the time of the occurrence of this event and when this event comes to an end, this information has to be given. Besides that, if the company is beginning its commercial production, or if there has been any changes due to the legal framework, or there is a disruption in the company's operations due to natural calamity, or the company has involved into any litigation, or there is changes in the prices because of the changes in the legal regulatory framework, if there has been change in the ratings of the company, all this material information has to be given to the stock exchanges, because all this information has a bearing on the performance of the company and their price sensitive informations. Then under clause 40A and 40B, the minimum level of public shareholding and takeover offer has to be informed. Rule 19 of the SCRA rules has made it now compulsory that every public company should have minimum 25% of the public shareholding. So, in the case of companies where the companies they do not have this requirement, the promoters they have to offer their shares for sale, or they have to offer their shares to the public. They can do it in the primary market or they can do it in the secondary market also. So, all details have to be given, and if there has been any takeover offer for the company or acquisition offer for the company, the details have to be given by the company under this clause. Then clause 41 is a very important clause. It says that company has to give half yearly financial statement if there has been any variation in the revenue or total assets or liabilities of the company, or profit and loss in the consolidated financial results, and this variation is 20% or more from the last audited financial statement which was filed by the company. So, if there has been a variation of 20% or more, then the company has to file half yearly financial statement also to the stock exchange. And clause 41 says that every public company should have a company secretary, and who should take care of the due diligence for the share transfer, and he will be the person who will be responsible for the compliance under the act. And clause 49 is the very important clause. Everybody knows about that this clause relates to the corporate governance. So, over here who are the CEO, COFO, who are independent directors, how the board of the company has to be constituted, how many independent directors, executive, non-executive directors should be there, and how the certification has to be done, what relationship directors should have the company, related party transactions, all such information has to be given under the corporate governance clause of clause 49, and the code of conduct has to be developed for the managerial personnel, and what is the internal control system, whether it is effective or not, all this information has to be given, and also an auditor's report has to be taken on the compliance of the corporate governance norms. So, this has to be filed with the stock exchange. Clause 53 is with the agreements with media companies. If a company is having any agreement with the media company or any of its associates, then that agreement has to be disclosed. If there is any shareholding given to the media company, if is having any nominee in the board of directors of the company, or if there is a possibility of any potential conflict of interest, all this information has to be disclosed under clause 53. And then clause 54 says that a company should have a functional website giving shareholding pattern, the operations of the company, the business of the company, board of directors of the company, annual reports, last published annual reports. All such details should be available for the investors on the functional website, so that before applying for allotment of securities, they can look into the website of the company to make an informed decision whether they should invest into the securities of this particular company or not. So over here we see that all these agreements, all these clauses of the listing agreement, they are indicative that the stock exchanges want to have every information which has some bearing on the investors' interest, so that all this information, any changes, continual disclosure is made by the company to the stock exchanges. Now let us come to delisting of securities. So we have, when we say we have listed our securities, we have entered into an agreement with this stock exchange, and the stock exchange will provide the facility for trading of securities on the stock exchange. When we say delist, that means now we are cancelling this agreement of listing, so that further after the agreement is cancelled, no trading facility will be provided to those particular securities which have been delisted. So delisting can be of two types. It can be voluntary delisting and compulsory delisting. And voluntary delisting, when the company itself makes an application for the delisting of securities, then it is voluntary delisting. And if it is compulsory delisting, then the stock exchange takes a decision for delisting of the securities. So voluntary is dependent upon the need of the company, the reasons are with the company. Compulsory delisting, the reasons are given by the delisting regulations, that these are the reasons for which the company can, for which the stock exchange can go ahead with the delisting of securities. And there is a requirement of continuous listing under rule 19A of the companies of the SEBI of SCR regulations. And one has to understand over here that when it is delisting, it does not mean that it is buyback of securities. Buyback of securities is done by the company, but in the case of delisting of securities, promoters buy these securities. So that is why the promoters, they have to give their money, use their money for delisting of securities, and delisting means now they are not, the securities will not be available in the trading platform. So the shareholders may want to exit the company because they had invested into the company to earn certain returns through the trading of the securities, and if the trading is not possible on nationwide terminals, then obviously they would like to exit the company. So over here one has to make understand that there is a difference between delisting and buyback of securities. Now let us understand about conditions of delisting. So delisting is not permitted in certain cases. For example, if it is pursuant to buyback of securities, if the company has bought back securities, they cannot be delisted. They have to be extinguished as per the provisions of the Companies Act applicable to buyback of securities. Then if a company makes a preferential allotment of securities, then it cannot go ahead with delisting of those securities. And if the securities are listed at least for a period of 3 years, before that they cannot be delisted. So a minimum listing should be there for 3 years before the company goes ahead with the delisting of securities. And if any convertible instruments are outstanding at the time of the delisting, and these convertible instruments, they are convertible into the same type of securities which are proposed to be delisted, then the company should not go ahead with the, or rather company cannot go ahead with the delisting of these securities. So these are the 4 conditions or exemptions where the delisting is not possible. The promoters, as I discussed earlier, promoters they cannot use the funds of the company for the purposes of the delisting, and in order to provide exit opportunity to the shareholders, they have to use their own funds. And promoters or any other person is restricted, they are not allowed to employ any device or artifice or a scheme or make any kind of transaction which operates as fraud on the shareholders, or which is fraudulent, manipulative or deceptive. So these are two conditions which the promoters have to keep in mind. Now let us understand what is voluntary delisting. As I told you that the company itself decides to voluntarily delist its securities. The reasons can be like company does not want to further go ahead with the statutory compliance, or the company has been losing on the trading of securities, or company has suspended its business, or company has become a sick company, or it is restructuring itself, or it is going ahead with reorganization of its share capital. Then the company may go ahead with voluntary delisting. Obviously the regulations cannot provide the reasons for the delisting, but if the delisting has to be done, then the procedure is provided by the regulations. Now what is exit opportunity and when it has to be given? Exit opportunity is given to the shareholders when the securities, when those shares are being delisted from the securities, and they are delisted from the nationwide terminals like NSE or BSE. If they are available on regional terminals but not on the nationwide terminal, then the promoters, they have to give this exit opportunity to the shareholders, that since from now onwards after the delisting, trading facility will not be available. So in case you want to take back your money, we can pay you, and we can take back your shares, and the shares are taken back or bought back by the promoters in for the sake of delisting. So exit opportunity is the opportunity given to the shareholders to exit the company and sell their shares back to the promoters of the company. So exit opportunity is necessary only when the nationwide trading facility is not available, otherwise it is not compulsory for a company to give exit opportunity. And for delisting also, the promoters, they have to take an in principle approval from the stock exchange, and for this purpose now the reverse book building process applies over here. And what is reverse book building? The promoters, they come up with offer of delisting and they ask the shareholders of the company that at what price they are willing to sell their securities to the promoters of the company. So a floor price is fixed and then a final price is fixed on the basis of the reverse book building process. So on the basis of the floor price multiplied by number of securities, the similar securities outstanding in the market, that amount is calculated, and the promoter has to keep that amount in the escrow account, which will be used for the purposes of paying back at the time of exit opportunity to the shareholders. So the final price is decided on the basis of the reverse book building. When the book closes, final price is decided. So whatever is the balance required, promoter has to provide the deficiency of the amount in the escrow account. Let us now understand what is compulsory delisting. So compulsory delisting is done by the stock exchanges. The reasons are given under the regulation. The first reason is that the company has incurred losses for preceding 3 consecutive years and has a negative net worth. Second, there has been a suspension of trading in securities for more than 6 months. Third, there has been infrequent trading of securities during the preceding last 3 years. The company, any of its promoters or directors, they have been convicted to comply with the provisions of SCRA, SEBI Act or the Depository Acts and the rules and regulations which are framed under them, and they have been awarded a penalty of not less than 1 crore or imprisonment or not less than 3 years. So this is the fourth ground. Fifth ground is that the addresses of the company or any of its promoters or directors are not known, or the false addresses are given, or the company has changed its registered office without information to the stock exchange, and the company's public shareholding has gone beyond the below the minimum level which is required, and company has not been able to raise it within the prescribed time limit. And so these are the grounds on the basis of which the compulsory delisting can be ordered by the by any stock exchange. Obviously an opportunity of hearing has to be given to the stock exchange before finalizing the decision on this, and the decision of delisting is to be taken by a panel which is constituted by the stock exchange as it is prescribed under the regulations, and public announcement of the delisting has to be made by the company, and the price of the securities at which the exit opportunity will be given to the shareholders, that price has to be decided by the independent valuer, and who will be deciding upon the or determining the fair value of the delisted equity shares. Now there are certain special provisions, so I will read these special provisions for you. In the case of a small company having a paid up capital of up to 1 crore with no trading of its equity shares in 1 year immediately preceding the date of the decision of delisting, or the company has a 300 or less number of public shareholders and the paid up value of shares held by them is less than 1 crore, the company is not required to follow the procedure given for exit opportunities. So these are the special provisions for the delisting of securities. Let us now take an example of Trichy Distilleries and Chemicals Limited. This case was decided in 2011. So in this case the issue was that whether 90% of the shareholders in number or shareholders holding 90% of the public shareholding in value irrespective of their numbers should consent for the delisting proposal. So whether they should be shareholders 90 in numbers or shareholders irrespective of their number, if they are holding 90% of the shareholding of the company, they should be entitled to vote for the delisting proposal. So in this case the company was able to get consent of more than 90% of the shareholders in value, but the number of shareholders giving consent did not add up to 90% of the public shareholders. So the Madras Stock Exchange refused to go ahead with the delisting, to approve the delisting by the company. So it was decided later on when the case went into dispute that if we go by the provisions of the Companies Act, which says that one share is equal to one vote, so this means that it would lead to absurdities if the consent of 90% public shareholders in value was not accepted. So this was a case which was decided by the in the year 2011. So over here there have been a number of statements which have been made publicly in the newspapers nowadays about delisting of regulations, and there should be review of the delisting regulations because some of the companies are finding the process to be very cumbersome, and a lot of efforts have to be made by the company. So a review of the delisting regulations has been proposed, and the SEBI also wants to restrict the delisting procedure so that the possibilities of manipulation in the case of delisting is avoided, because delisting is totally in the hands of the promoters of the companies. So in order to have any kind of tacit understanding between promoters and a few shareholders where the price manipulation of the securities can be there, the SEBI is under reviewing under this review of delisting regulations, and the major changes which are being discussed are that we should reduce the time period of delisting which is given for 250 days, because this is a too long a period, because there are chances of price manipulation of the stock. There can be manipulation of the prices by the non-promoter group. There is a suspension of trading after the announcement of delisting, so 250 days are a long period for that, and sometimes demand of the securities is also less. So the discussion paper was proposed by SEBI for reviewing delisting regulations. So they are working on this, and although the revised regulations have not been imposed so far, they have not been enforced so far. So under the review under the review or the discussion paper, the process of reverse book building, the time which is taken, and the informal arrangements which have to be made, the procedure should be made a little simple for the companies for delisting of securities. All these issues are under discussion with the SEBI. Let us now take few examples of delisting. In 2014 August 17, Hira Ferroalloys Limited was acquired by Hira Infratech Limited. Public announcement about the exit offer was made by the acquirer company, and it was made through Motilal Oswal Investment Advisors on August 7, 2014. Then the first public announcement was made on May 16, 2014, and it was in respect of the proposed acquisition and voluntary delisting of fully paid up equity shares of the company from the Bombay Stock Exchange, Madhya Pradesh Stock Exchange and NSE, and letter of offer was issued on May 20th to the shareholders for inviting bids from all the public shareholders, and post offer public announcement was made on June 26. So, you see that first of all an announcement is made, public announcement is made, and offer letter is sent to the prospective shareholders. Then the second public announcement is also made after the book building process is complete. Then in another case, in the case of Piramal Glass Limited, public shareholders, they were informed through the public announcement on July 22, 2014 by Kotak Mahindra Capital Company Limited on behalf of Shri Hari Trust, which acted through its corporate trustee PEL Management Services Private Limited, about the proposed acquisition and voluntary delisting of fully paid up equity shares of rupees 10 each of the company wide public announcement, which was made on April 25, 2014. Acquirer had fixed the exit price of rupees 140 per share, which was calculated by the reverse book building process as we discussed. All shareholders who tendered their shares through valid bids at or below the final price, they were paid accordingly. Promoters group's shareholding increased to 90.85% after the acquisition, and the company applied for delisting to NSE and BSE, and the company had made an offer to residual shareholders to tender their shares at the same terms and conditions. So, over here you see that promoter shareholdings increased to 90.85% after this delisting, and we know that promoters cannot have more than 75% of the shareholding. So, after delisting they have again to reduce their shareholding to meet the norms. While writing this module, certain changes were proposed in the delisting regulations by amendment of 2015, and in these amendments I will consider only the major amendments which have been proposed in these regulations. So, first amendment, which is very important, is to know is what are the conditions for delisting. Now, one more condition has been added for delisting, and the regulation says now that delisting is not permitted pursuant to buyback of equity shares or a preferential allotment made by a company, or unless the specified securities have been listed for a period of 3 years on the stock exchange. If any convertible instrument issued by the company are outstanding and they are convertible into same class of equity shares that are sought to be listed. The new condition which has been added is that the delisting is not permitted if any entity belonging to promoter or promoter group has sold equity shares of the company during a period of 6 months prior to the date of board meeting approving the delisting proposal. Another change which has been made is about the exit opportunity and the procedure for the exit opportunity. So, where in the case of voluntary delisting exit opportunity is required to be given, this proposal has to be approved by the board of directors of the company and public notice should be given, and the application to the concerned recognized stock exchange for delisting of equity shares should also be given. The board of directors has to approve and they have to make a disclosure to the concerned recognized stock exchange, appoint a merchant banker to carry out the due diligence process, and obtain trading details of shares of the company of top 20 shareholders of the company for a period of 2 years prior to the date of the board meeting when they are working on approval or the approval of the resolution for the proposal of delisting. Then the board has to certify that the company is in compliance with the applicable provisions of securities laws and conditions for delisting, as well as the delisting is in the interest of the shareholders of the company. So, these are 3 changes which are made in the case of voluntary delisting where exit opportunity is required to be given. Another major change is about when an offer is deemed to be successful. So, in 2009 regulations, an offer was deemed to be successful if post offer the shareholding of the promoter taken together with the shares accepted through eligible bids at the final price reaches the higher of 90% of the total issued shares of that class, excluding the shares which are held by a custodian and against which depository receipts have been issued overseas, or the aggregate percentage of the pre-offer promoter shareholding and 50% of the offer size. So, the shares will be accepted only when the final price reaches the higher of the two. In 2015 amendment, an offer shall be deemed to be successful only if the post offer promoter shareholding taken together with shares accepted through eligible bids at the final price reaches 90% of the total issued shares of that class, and at least 25% of public shareholders holding shares in the demat mode as on the date of the board meeting have participated in the book building process. So, you see that these conditions, they have been now they have been made more strict depending upon the promoter's shareholding as well as the participation of the public shareholders in the delisting process. So, these are the changes which are proposed by the new amendment which is made in 2015. So, in this module we have discussed about listing and delisting of securities, and we refer to the SEBI regulations, especially delisting regulations of equity shares 2009. We refer to SCRA, its rules and regulations, and we also refer to Companies Act for allotment of securities. Thank you very much.